but I am super excited. I'm Michelle Blakely. I own See, Jake, and Jane Train, helping outstanding fitness professionals be brilliant business people. And I am so excited to have this six expert series as part of our Fit Pro Summer School. Today with us, we are kicking off with one of my favorite people, one of my favorite consultants. This is Melody Ashby from Meyer Law. And Melody is a seasoned, outstanding attorney at Meyer Law Firm. She is a trusted counsel of mine for nearly a decade. She's helped me with contracts, negotiation, employment items, intellectual property issues, fellow Fit Pros. She is also just awesome. So I know lots of us have a little bit of an aversion, no offense, attorneys out there, to the legal side of things. But Melody is warm and lovely and kind, and she ensures that when she's speaking to you, you understand what she's talking about. What is also so awesome about Melody is has that lovely, warm presence, but she fights for you. Like, I always feel protected. There was one contract negotiation where I remember she was like, no, like that is not how that's going to go. That puts you completely at risk. So absolute huge asset. And we do need attorneys to run our business as well. So we are thrilled to have you, Melody. Yay, yay, yay. Thank you for making the time.
Thanks so much.
As promised, you're welcome. As promised, we are going to try to knock out 3 burning questions in 30 minutes. Did I cover everything okay, Melody? Do you have anything else you want to say? Okay,
Yeah,
awesome.
I'm excited to be
Good.
here with everyone. So,
Awesome. Okay, so question number one. Can you share the importance of being a legal entity, right? Sole
yeah.
prop, LLC, S Corp, C Corp, and if it's a good idea for me to set it up myself or with my brother-in-law or to hire someone.
So, I mean, here's the thing. When you're just starting out or if you're just doing business as yourself, you are a sole proprietor. But the main thing that happens with a sole proprietor is that there's just really no legal distinction or separation between you and your business. And so when you set up an entity, and if you talk to any attorney, they're going to advise to set up an entity to just segregate everything out. The entity itself is a legal being separate from yourself. And so what that does is it allows you to not be personally responsible or liable for your company's liabilities, obligations. So ultimately creating a separate legal entity not only safeguards your personal assets, but then also ensures that you're following all applicable state, federal laws as it relates to your business. I would say another benefit of setting up a separate legal entity, depending on how you set up, would be that it could allow you to obtain certain tax savings, again, depending if you're an LLC with partners versus setting up a corporation with maybe an S election, which I could get into those specifics if anyone's interested. But another reason to set up a separate entity, I would say, is just conducting business allows for you to keep things a little bit more formal, like banking operations, helps you reduce problems associated with commingling your assets. So again, that comes down to liability. A lot of times we'll have clients that are operating as a sole proprietor, or sometimes they have a separate entity, but they're still commingling assets. And that's a big no-no. You don't want to commingle business and personal because then you're exposing yourself from a liability perspective. Because really, you have to follow the formalities of your business in order to ensure that you're actually protecting yourself personally. And then one other huge benefit, I think, to setting up a separate entity from yourself, if you form a company, you could actually have it continue on beyond your own existence. Maybe you want to transfer it to another party. Maybe you want to sell your business. You really can't do that when you're a sole proprietor because as a sole proprietor, you are the business. What is it that you're actually selling at that point? And if you want to set forth, safeguards to carry out your intent as far as transferring ownership, if there is a death or a disability, having a separate entity allows you to do that a little bit more seamlessly. And so I think those are all really good reasons. Another reason, just not necessarily legal, but from a business perspective, would be if you have your own separate entity with its own employer identification number, you can start building business credit separate from yourself. And there's a lot of banks and certain states even require, in order for you to have a business account, to have a separate entity. Not all states are like that, but there are some states that restrict that. And also, again, being able to get potential loans for your business to help accelerate it as needed. And, a lot of times it's a lot more simpler to do when you have a separate business entity from yourself. And if you're looking to choose the type of entity, that comes down to personal preferences. I wouldn't say that there's one entity that is superior and can do all things, right? It really depends on your goals, where you're going, what it is that you're looking to do. What I will say to sole proprietors who are setting up limited liability companies, LLCs are meant to be two or more people, and it's completely fine to be a single owner in a limited liability company. It's just that you don't get the same tax benefits if you are a sole owner in a LLC. You're just going to be treated like a sole proprietor from a tax perspective. What's nice though about LLCs is the flexibility of doing business. So you could actually change the tax election. You could choose to be taxed like an S corp or a C corp, or you could add another party in and be taxed like a partnership. So there are pros and cons. I would say probably from a tax perspective is the major factor that most clients will use to determine the type of entity. Of course, other factors such as will you have partners? Are you going to be fundraising? But for a lot of sole proprietors, and especially in the training space, it might make sense to be set up like an S corporation, or if you're a consulting business, that helps because what happens is you treat yourself as an employee. You pay, your taxes on it, but then there's tax-free distributions that can occur. You just don't get those tax benefits when you're a sole proprietor. And so looking at, what makes sense for your specific scenario can be really ideal in determining the type of entity, but we definitely would recommend creating that separate entity. And whether you do it yourself or not, it depends again, I think, on the type of entity. I think creating a legal entity yourself is a good idea if you have a clear understanding of the legal requirements and the process involved. And again, depending on the type of entity that you set up, it could be time consuming if you're just not familiar with it. And so in that case, you might be better off just paying somebody else to assist you. And then you just don't want to make errors in the formation process because that could lead to issues down the line if it's not set up properly. Ultimately, though, if you're looking to set up like a limited liability company, they're pretty straightforward. The one thing that I think a lot of clients fail to do when they set up entities themselves is they might get the initial registration completed, but there's additional compliance that needs to be done after you form the legal entity. There's, organizational minutes. If you're an LLC, you might have regulations. For corporations, there's additional paperwork like bylaws that need to get in place. Some states require that additional paperwork. And so you just don't get that generated when you file yourself. It's an additional step that needs to occur. And then I would say, though, if you are looking to do it on your own, ultimately, you just need to decide on the type of business structure that makes sense. You could use a service. Some are better than others. I would definitely say that you want to seek out expertise if your business model is complex, or if you're looking to form a corporation, because there's nuances with franchise tax depending on the states that you're filing in. And you want to make sure that, based on the number of shares you're authorizing, there's just more nuances with that. Or if your business involves multiple owners or stakeholders, you'll definitely want to seek out advice from counsel first before you make a decision so you can understand the structure of that. Or if your industry is just really heavily regulated and you might not have time to dedicate to the process, then that would be another scenario. So I know one of your questions was, hey, can my brother-in-law do it? I would say, yeah, if your brother-in-law knows how to set up that entity, I think that would be fine to do. But ultimately, I think the decision comes down to your confidence in handling those legal aspects of the business formation and your willingness to invest time and executing the necessary steps. But if you do have doubts or specific legal concerns, it doesn't hurt to just get at least an initial consultation with an attorney or some other professional service just to give you some peace of mind based on the decisions that you plan on making.
Yeah, I mean, wow, she answered it all, didn't she, guys? This is what I mean. This is what I mean about this one. So I want to bring up 2 points about what you said, just because I'm the call that gets, I'm the call before you, right? So my fit pros tell me what's going on, and then I say, oh, we're out of my scope, and I refer them to you. So guys, I want everyone to make note, when Melody was saying commingle assets, if you're taking Venmo payments to your personal checking account for the digital program designs you're sending out, right, that you threw out there during COVID, that is commingling assets. And if, God forbid, you're in front of an attorney, Melody, correct me if I'm wrong on this, you are not behaving like a business, like a legal entity in that moment, which then can create some gray area and you kind of expose yourself. Is that accurate or no?
Yeah, what ends up happening is when you create a separate entity from yourself, you have to treat it as a separate entity in order to maintain that liability protection. If you create a separate entity, but you're commingling your personal assets, buying groceries with the company's, credit card or whatever the case may be, what ends up happening is if you're ever involved in a lawsuit and these things come up where it's shown that you're not actually creating a separate legal entity from yourself and you are commingling, then you kind of are in a situation where you're leaving yourself again personally liable, and you don't want to be in that scenario. So you just want to make sure that you are creating a separate legal distinction, and you can have sharing of fees as long as it's all tracked appropriately, right? Like obviously as a business, you might need to make a distribution to yourself to pay your rent or whatever the case may be, but you just need to make sure everything's tracked appropriately and that decisions are made amongst the company and yourself individually that are separated.
Yeah. And I love your advice to, um, yeah, you can do it on your own because I've seen both with my clients, right? Some we'll have the conversation and they'll say to me directly, I don't have the time for it. I want it to be done right. It's worth it to me to pay, you know, a couple $1,000s or whatever it is. Just have this person, this law firm set it up for me, and then it's done and it's good to go. And then I have them as a resource moving forward. And I've also had other clients who they don't mind detail work, they don't mind paperwork, they don't mind reading through everything really carefully, and they'll fill it out on their own. But usually, even if they go that route, they've had a conversation with an attorney and they've had a conversation with an accountant first to just pick
Yeah.
which entity they're going to be. So
Oh,
I
I
think
have
that's
clients
great.
that do things on their own as well, and I'm totally fine with that. I just always like to have that initial conversation to make sure that they're not going to make a mistake based on what it is that they're proceeding with. And I'm totally fine with people picking and choosing and allocating their resources as needed. But like you said, I think it just always depends on the scenario and how much time and effort somebody's willing to put into it.
Right. Okay. Phew. Question one down. All right, question two. And we're going to kind of take this one from both sides, guys. Okay. And I'm trying to stick with the 30 minutes. Anyone who knows me well knows that was a challenge I gave for myself. I love to talk. I love to listen. Look at all the smiles out there. They know it. They know me. She's a talker. Okay. My former employer is trying to sue me for working nearby or quote unquote stealing clients. What do I do? What is that about?
Yeah, so I think the first thing is you need to understand the situation. Not every situation is going to be the same. So, what agreements did you end up signing with your employer or with a company? Did you sign any non-compete agreement? So, your former employer might claim you're violating terms by working for a competitor or similar business nearby. Or there could be a non-solicitation clause, and those clauses actually prevent you from soliciting your former employer's clients for a certain time after leaving the company. Or there could be confidentiality agreements that you signed where they're protecting trade secrets, and maybe your former employer may allege that you've stolen their confidential information or trade secrets and are using them for the benefit of yourself or for another third party. So once you understand what obligations you're under or what contractual terms you signed, then you take the next steps, reviewing those contracts, carefully understanding the terms, figuring out whether or not they're enforceable. Here's the thing with non-solicits, non-competes is that every state's a little bit different. You have to look at the state where the employee is residing and working to determine what terms actually will take precedence and hold. And then obviously in this context, I would always say you really want to seek advice from an attorney who can understand your rights and obligations and maybe even formulate a defense strategy for yourself. Collect any evidence, documentation that supports your specific claims. You want to, I would say at that point, if they put you on specific notice, maybe refrain from contacting specific clients until you understand from a legal perspective or get legal clarity on what is and is not permissible at that point. And then I would just keep a detailed record of your business activities to show whether or not it's prohibited. Now, as far as like legal considerations in general, so, enforceability, like I mentioned, of non-competes and non-solicits they have to be reasonable in scope, in duration, in geography. Courts can obviously refuse to enforce overly restrictive agreements as well. And a lot of jurisdictions have laws that are essentially limiting the types of, I should say, limit the enforceability of some of these agreements,
Yeah.
particularly with certain industries. And then you just want to show that you've acted in good faith and didn't try to intentionally violate any agreements. Generally speaking, now, as everyone has probably heard, the FTC has adopted some comprehensive ban on non-competes with all workers. And so existing non-competes with workers, other than a few senior executive exemptions, are not going to be enforceable after the effective date. It becomes effective this September. And so if you did sign a non-compete, just know come September, it's likely not going to be enforceable whatsoever. And so it's an interesting landscape right now because you might be dealing with a non-compete issue, but like if it does go to court, it's kind of one of those scenarios where, well, let's just wait a few months because as of September, we can just say that it's not going to be effective anyway. And by the time it gets to court, and if you do end up doing any type of litigation, it may not even be worth the paper it's written on. Now, on the flip side, non-solicits can be enforceable, but again, it depends on the state. And if your non-solicitation operates similar to a non-compete, then it could be considered not enforceable. So it's always going to come down to the language in the paper that it's written on. There's so many arguments throwing out non-solicits, especially if it's overly broad. So if you've signed an overly broad non-solicit, you can make arguments if, the burden of proof would be on the employer to show that it, number one, is enforceable and how you actually violated it.
And just to be, that's all super helpful. And just, I don't mean to offend anyone, all my, business owners out there that already know this, but in case there's a few people that don't, Melody, correct me if I'm wrong. Non-solicit in a very simple term is taking of clients from the business you were at. Non-compete is setting up shop nearby that is violating something you signed that said, no, you're not going to, within the next 5 years of leaving, you're not going to set up a business 10 miles away from us or closer, right? Those are the differences between the two. I know that was, we shared that in the 9-week turnaround, but I'm not sure if everybody knew that. And so those are the two different, is that an easy way to phrase both those things?
Yeah, exactly. That's an easy way to separate them. It's just that sometimes in these agreements, non-solicits are written in a way where it almost creates a non-compete effect. And so that's why I said, like, you just have to go back to the four corners of the document, because if it is written from a non-competition perspective, where you're not really being reasonable in the reasons why it's being protected, then courts will likely consider that a non-compete. And so it's always specific to how the language is written. It needs to comply with state law for sure in order for it to be enforceable.
And these are documents you signed when you were hired as an employee at an organization, right? And sometimes I have trainers who they'll say, it's 3-4 years later and now they're branching off and opening their own thing. They don't remember what they signed, right? So you're saying they need to get a hold of it and really read it through so nobody's, trying to take advantage or pull something over on them, right? Okay. And then for our studio owners or people looking to open studios on the other side, if we have just a quick minute to address I would say maybe the importance of having these things.
Yeah. So definitely what I would say is that courts will maintain and enforce any terms. Like, so for example, confidential information. If you are keeping your customer or client list confidential, you have your employees or contractors sign confidentiality obligations to protect that. You just have to maintain those reasonable standards to show that you're actually trying to maintain that as your confidential information. If, on the other hand, you go and you have a whole list of your clients on your website, guess what? It's not confidential, right? So you have to, keep your practices in line with your agreements. And if you change your practices, then your agreement should shift and change with you. A lot of clients, for example, might go down the route one way and then they shift their practice, but never update their contracts. And so you want to make sure that everything's kind of aligned with the business and everything potentially changes. We always like to say, take a look at your agreements on a yearly basis to see what has actually changed in your business practices and then update that accordingly. But the way that you can still protect yourself from a studio perspective is make sure that your non-solicit is compliant with state law. If you are concerned about, individuals taking or trainers, for example, taking your customers or clients, keep in mind that you are in an industry where you make personal relationships. And if the client ends up wanting to follow the trainer, there's not much you can do unless you have an agreement with your client saying that, hey, you're not going to solicit and work circumvent and go around us to work with this particular person. So you can protect yourself on both sides, both fronts if you wanted to, both with your trainers or employees, and then also with your customers if you wanted to add restrictions around your working relationship. But just make sure that your agreement is compliant with state-specific laws, because there are some states that will not enforce non-solicits as well. So you just need to make sure that you're reviewing all of your contracts and to ensure that they're clear and enforceable.
I think that was a great point. Like once a year, just do a check-in. And I think that's so much of what it's hard for us to do. And it's, part of why I do what I do. And, people make the time to invest in working together is, listen, I need help and reminders to work on my business. because I'm so busy working in my business, right? Things like that can fall through the
I
cracks. I
mean
think that's an
I mean,
awesome suggestion.
especially with employment law, there's new rules every year. So it's like, it's one of those things where you just have to kind of stay on your toes and make sure, like, if you do have employees, that you're keeping up with all of the various compliance, because it can feel like a lot, because I feel like every year there's a new change in employment law based on given states. So
Yeah. Okay. Awesome. Thank you. All right. Last one. Question number 3. What do I need to legally protect myself if I sell virtual training or hybrid programs online? So, Melody, in our world, when we say hybrid programs, it means maybe we're training them in person in real time or via Zoom in real time, like like this, like how we're talking right now, or um, and digitally sending them workouts or videos of workouts that they're going to do on their own. So the question is, how do trainers and studios protect themselves if their services have become pretty digital?
yeah, so I would say number one, and this would apply, I guess, to any business, whether it's digital or not, is consider incorporating your business if you haven't done so already. And again, to protect your personal assets and business liabilities. Number two, think about your intellectual property protection. What is it that you want to protect? If you've come up with a program name, a logo, a unique business name, consider trademarking it. That protects your IP rights. If you have original content, such as training materials or videos or written content, you can think about getting a copyright for those items or filing separately for them.
Mm,
And then the main thing I would say for your digital programs are get contracts and agreements in place. Get, for example, terms of service, comprehensive terms of service outlining rules, guidelines for how somebody can use your platform, how they can interact with the content. If you want to put restrictions around, somebody sharing that content with others that did not, for example, purchase them, you could put all of those restrictions in your terms of service. You'll need a privacy notice to the extent you're collecting any personal information, and that should comply with data protection laws, which is another, I would say employment and privacy is constantly changing on a year by year basis. But in a privacy notice, you're going to explain how you collect, use, and protect user information. And for most digital programs, you're collecting some portion of personal information there. And then if you're doing licensing your content, maybe to other trainers or third parties, again,
hmm
sure you have licensing agreements in place, or just develop great service agreements that detail, all of the limitations or restrictions that you want to put into place. Ultimately, I would say, you'll also want potentially liability waivers if you don't have them already. So require participants to sign liability waivers acknowledging the risks associated with your training programs, and then get insurance for your business if you don't have insurance already. And that's just going to be additional protection for purposes of your business and any claims that come about.
And guys, what's awesome about getting the liability insurance, which anyone who has ever taken a call with me, we've covered it and I've said it, and it's that, first week of the 9-week turnaround kind of thing. It also can, depending on the policy you get in our industry, protect your client. So I had a colleague who pointed out that, our NSCA insurance has like $5,000 of coverage for an injury. Like, so that means no fault, no problems, no anything. A client sprains their ankle in a workout, that it'll cover them too to go get, care and be okay. It's not always a terrible situation. So there's multiple reasons to make sure you have yourself incorporated and you do get liability insurance. To that point too, I would also say make sure you get enough. So a $25,000 policy is not going to be enough. We want to be in the millions. If you have questions about that specifically, you can ask me. Oh my gosh. Okay, we have 3 minutes left. Very excited. We're on time. Does anyone have any questions you can throw in the chat? And I know it takes a second for them to pop up, but please throw something in. Or actually, if you want to ask to be taken off of mute, you could ask really quickly. Otherwise, I'm going to ask Melody a question, and we'll stop if somebody pops in a question from the audience. If we all left only doing one thing, what would the one thing be that you want us to do to
Uh,
be safe and protected?
I would say if you're going to do one thing, get a legally sound contract for your services in place. If you don't have a
Okay.
contract and you don't have, for example, that limitation of liability clause, which is always that in all caps in the contract that like is screaming at you, it's on unlimited liability. Your risk should always be proportionate with the reward, meaning if your client's paying you, $5,000 each quarter for services, you shouldn't take on more liability than what you're receiving in return. And really, the only way to limit that liability is to have a legally sound contract. So it's a single step that can provide significant protection and clarity for all parties involved. And so my whole thing with contracts is it just sets clear expectations for both parties, and then it just reduces misunderstandings and disputes and can really save you in the long run with your services.
That's a brilliant recommendation. I love that. I think it also goes in line with, having clear policies, clear expectations. You're talking it through. Everybody knows what's going to be delivered and what to expect. So that's brilliant. I think all of this was so helpful. Thank you to everybody that attended. I want to remind you that today's the first day of Fit Pro Summer School. I'm so happy to have some of you in it. If you have colleagues or if you're joining us as a guest today and you want to sign up, scroll to the top of the chat, and there's a link to schedule a call with me and we can talk it out. We are honored to have had Melody Ashby with us today. Yay! What does the Zoom thing? Will it make claps if I do that? I don't know. Anyway, it always does it at the weirdest moments, right? I'm making like a serious gesture, and all of a sudden, like a thumbs up bubble floats past my face. Go up to the top of the chat, guys, and if you need anything legally, I cannot recommend Meyer Law highly enough. There's a link right there at the top from me that has both Meyer Law's homepage and Melody's direct email address. So thank you, everybody, for joining us. We really are happy to have had you here and hope this was really helpful. And we'll see you next week. But a giant thank you, Melody. Appreciate it.